Hi, my name is Goldman. I'm the founder and director of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. We've talked a little bit about the absentee parent as it relates to support. Well, what about as it relates to custody? Let me paint the picture for you. The two parties get divorced. They go through all the issues, custody, parenting time, child support, property division, all of these great things. And now it's finally over, and there's an order of custody that determines some sort of situation, perhaps a joint situation. Maybe the parties share legal custody, which means important decision making regarding the child, but let's say dad has full custody, mom has some parenting time, mom has certain rights, but she shares in the decision making. And you know what she does? She ghosts everybody. She takes off. In the beginning, she exercises some parenting time, participates in some decisions, but slowly gets smaller and smaller and smaller, and now poof, gone. Now it's been 3 years. Nobody's heard from her, nobody's seen her, and there's still a joint situation here. She still has some rights. And the reason why it's important to highlight that is because even though she's been gone for 3 years in my example, if she were to show up and demand parenting time and demand the right to, weigh in on her kids, on the decision making and all that, you go back in the file and look at the most recent order, she appears to have the right to do that because the order is 5 years old, and at that time it seemed to be the appropriate thing to do, but it's no longer the appropriate thing to do. So, in a situation like this, what would be appropriate in this scenario is the father who has the custody and shares joint custody, he should file a motion to change it. He should file a motion to get sole physical and sole legal custody and suspend the parenting time until further word of the court. If he does that, then what will happen is all the decision making will fall to him. All the custody remains with him. The parenting time, which might have gone to mom, it's suspended. Suspended until she does something to change it. The court will hear from her, give her every opportunity to explain what she's doing or what she did or what she's going to do, and she'll have a right to assert that. But until such time as she does, what you can do as the custodial parent who's sharing decision making with somebody who's a phantom is you can change that order by filing the appropriate motions, have your lawyer file the petitions before the court, and actually change that order to reflect what is now your reality. Your reality is you are vested with all the physical custody and you're forced to make all the decision because even if you wanted someone to help you weigh in on those decisions regarding, let's say, religion or medical or anything important, educational, whatever, you don't have another person to talk to because the other person has ghosted us and departed. So in that situation, you need to have the full authority. You go before the court, your attorney files the appropriate petitions, the service is accomplished, all the documents are in, the court conducts a hearing, and the court will be asked and will grant your petition to change the custody from a shared environment to a complete situation where you have all the custodial rights. And again, if the other side wants to come back and make a change or make requests at a later time, they're at liberty to do so, but at least until such time as that happens, you are in a solid custodial position. If you have any questions about that, reach out. We'll be glad to help you out.